Quiet, please.
All right, back on the record in the Simpson matter. All parties are again present. Mr. Simpson is present with his counsel. Mr. Shapiro, Mr. Cochran,
Yes, good morning, Your Honor.
Mr. Spaulding, Mr. Bailey, Mr. Blazer, people represented by Ms. Clark and Ms. Lewis. Jury is not present. Anything we need to take up with regard to Ms. McKinney before we resume?
Yes, we do, Your Honor. I would ask Your Honor to listen to Dean Uelmen with regard to a proposed jury instruction.
Well, jury instructions come at the end of the trial, don't they?
They normally do, Your Honor. However, this is a unique situation. I think Dean Uelmen can explain it if the court will allow.
Your Honor, we have submitted a special proposed instruction that we would ask the court to give at the conclusion of Ms. McKinney's testimony. The genesis of this instruction is Section 412 of the California Evidence Code, which provides that if weaker and less satisfactory evidence is offered when it was within the power of the party to produce stronger and more satisfactory evidence, the evidence offered should be viewed with distrust. Our concern is that the jury may view the evidence with respect to the racial epithets in the tapes and transcripts with distrust, since they are not being given the opportunity to hear the stronger and more satisfactory evidence of seeing the transcripts themselves and actually hearing the tapes. So we believe it's appropriate under these circumstances for the court to inform the jury of the court's ruling and the reason why they are not being allowed to see the transcripts or hear the tapes. And we've fashioned a jury instruction which actually uses the language of the court to explain to the jury why they will not have that opportunity. In very simple and non-judgmental language, they would be informed that they will not be allowed to see the transcripts or hear the tapes.
Do you know of any precedents for a jury instruction like this, do you know? You ever seen one like this before?
Well, yes, I believe that on occasion courts have instructed the jury in the language of Section 412. And in fact, we will submit an instruction because we believe the prosecution has presented weaker and less satisfactory evidence when stronger evidence was available. But that instruction should not be used against the defense in the context of a ruling of the court that precluded the use of stronger and more satisfactory evidence when the evidence would have been offered but for that ruling.
All right. Do you have any case law authority for this proposition?
I do not, Your Honor.
All right. I'll hear from the people.
This is a very obvious attempt to have the jury focus on what they haven't seen and haven't heard. It's like, don't think of the marshmallow man. It's all you can think about, and that's what this instruction says. Think about all you haven't heard. Think about all you haven't seen. And that's the intent of this instruction. It's highly inappropriate. It seeks to highlight what the court has deemed inadmissible. What's the purpose of having rulings under 352 that make evidence inadmissible if all you do is turn around and tell the jury, guess what? There's all kinds of stuff you haven't seen. What's the point? And then you have their imaginations run wild with what they haven't seen. It's bad enough that they know that there are, 14, 11, 12 hours of tape. They've heard 1 second. I think that they get the picture. And the 41 or 42 times, every time Mr. Cochran asks her the question, it becomes 42, 43. We're going to be up to 470 if he keeps questioning her. But they get the idea. They get the idea plenty. They've heard 2 excerpts. They know he said it 41 times. They know he spoke to her for 12 hours on tape. All of that gives the jury the clear view that they've gotten a small snippet. All this seeks to do is highlight this matter, inflame the jury more, and get them to think about how awful the rest of the 39 or 40 times were in which he uttered the word. It's so obviously inappropriate that I don't even think I need to argue this any further. With respect to whether Section 412 could form the appropriate basis of a jury instruction, I don't think I disagree with that. I think that the court could appropriately instruct. That is the evidence code, that is the law, and it's available to both sides. if Dean Uelmen thinks that we are going to argue Section 412 with respect to this evidence, he is sadly mistaken.
Oh, I don't think that that would ever happen.
It will
I
not.
don't think that's the import of his argument.
Oh, I think that's exactly what he said, that the people would argue this instruction against the defense to point up the fact that they could have offered better and stronger evidence, i.e. more inflammatory, but they failed to. And in point of fact, I can assure the court and counsel that will never occur, not with respect to the tapes. They've got his voice. I think that's pretty strong evidence that he said it. So this is nothing but an attempt to highlight the inflammatory material that has been ruled inadmissible and to cause the jury to speculate on what they haven't heard and to imagine the worst, which I think, I don't know. It's already so inflammatory what they have heard, Your Honor. The defense has already gotten the benefit of the most prejudicial and inflammatory thing I think I've seen admitted in a court ever, you know, by virtue of what we have in Ms. McKinney's tapes. Now they want to have the jury speculate how much worse it gets. It's obviously improper.
All right, Mr. Uelmen?
Your Honor, the instruction tells the jury not to speculate. It's precisely the opposite of what's just been represented to you. The instruction suggests the court tell the jury you should not speculate about why you have not had an opportunity to see the transcripts or to hear the tapes. We're not inviting speculation. What we're trying to avoid is speculation under an inference ordained by the evidence code where the jury is invited to view the evidence with distrust because stronger and more satisfying evidence has not been presented. Our problem, of course, is that, as Your Honor concedes, the two excerpts that the jury has heard are among the most innocuous and least inflammatory of all of the evidence available. And Your Honor sustained an objection to Ms. McKinney's characterization of the evidence in that respect. We believe the jury should hear the reasons why Your Honor is keeping out those other 39 in the language that you used in your order. That your examination reveals that the epithet...
Counsel, you don't need to read my order to me. I know what it's there.
Well, we think it's appropriate for the jury to be informed of that order so they know why they're not hearing all 41 of these.
All right. Thank you, counsel. All right. I'll take the request for the instruction under submission for consideration at the time of the jury instruction conference. All right, Deputy McNair, let's have the jurors, please.
All right. May I just ask one question with regard to the question I asked Mr. McKinney yesterday? The court care to reconsider that, or whether or not I can ask her if she can characterize this, the one tape portion that was played as compared to the others?
No.
All right.
Thank you.
Thank you.
Let the record reflect that we've been rejoined by all the members of our jury panel. Good morning, ladies and gentlemen. All right, Ms. McKinney, would you resume the witness stand, please? All right, the record should reflect that Ms. Laura Hart McKinney is again on the witness stand undergoing direct examination by Mr. Cochran. Good morning again, Ms. McKinney.
Good morning, Your Honor.
Ms. McKinney, you're reminded that you were still under oath. Mr. Cochran, you may conclude your direct examination.
Good morning, ladies and gentlemen. Good morning, Ms. McKinney.
Good morning, Mr. Cochran.
When we concluded our day yesterday, we had played a tape for the jury. You'd shared with us that you identified for this jury that was Mark Furman's voice. Do you recall that?
Yes.
And with regard to the tapes, the 12 hours plus tapes and the transcripts we talked about yesterday, did you turn those tapes and transcripts over to the prosecution just as you did to the defense in this case?
Yes, I did.
And have you been interviewed and talked with the prosecution and cooperated with them?
Yes, certainly.
And you are out here from North Carolina pursuant to a subpoena, is that correct?
That's correct.
And you tried to cooperate with both sides?
Yes.
Now, with regard to these tapes and transcripts that we've been talking about, after the first interview that you had with Mr. Detective Furman in February of 1985 that you described for us, I showed you yesterday a series of questions which you sent to him prior to the second interview, is that correct?
That's correct.
And that second interview would have been in April of 1985, is that correct?
Correct.
Along with the questions that you sent him, did you send him a transcription of the tape of an earlier meeting or any transcription? Do you recall?
I sent him the transcription of our April 2nd, 1985 meeting, our first taped interview.
All right, and you sent that to him, and did he ever, as far as you know, make any changes at all on that transcription that you sent him?
No.
Now, later in 1985, did you have occasion to prepare a series of transcripts that you had prepared from the various tapes you'd conducted and send those to Mr. Furman?
Yes.
Will you tell the jury when that was, ma'am?
That was sometime in mid-June. I don't remember the exact date, but at that time I compiled all of the transcripts from our interviews and put them in a 3-ring binder with indexes and dates similar to the way I was logging the transcripts and keeping them for myself.
And did you give those to him or mail those to him, or what did you do in that connection?
I gave those to him in the binder.
Did you ever at any point get any of those, the transcripts that were in the binder, back from him with any changes?
No.
And so that we're clear about what was inside the binder, it contained some hours of the transcriptions of the tapes you'd had with this particular individual. Is that right?
That's right.
Did he ever give back the bound volume to you?
No.
So as far as you know, he still has it. Is that correct? Well, as far as you know, he still has it, right?
As far as I know.
Now, yesterday we talked about Mr. Furman's role as a technical advisor or a consultant. Was he to be paid if the screenplay was ever sold by you?
Yes.
And what was that compensation to be?
$10,000.
Has that screenplay been sold?
No.
And with regard to these tapes or interviews that we call interviews of Mark Furman, you have not tried to sell those tapes yourself, have you?
They're not for sale, no.
You're not trying to profit from those tapes, are you?
No.
Now, with regard to the references of the so-called N-word that we talked about, we talked yesterday, and I think the two examples that we were able to play for the jury, I think you said it occurred maybe in April of 1985. Is that correct? The two examples occurred in 1985?
Yes.
And do you recall the first one about where he grew up? When was that?
That was during our...
Haven't we covered this already?
Perhaps so, Your Honor. It's leading to another question, Your Honor.
All right.
Thank you. When was that?
That was during our first interview.
All right. And the
April
second
2nd.
one, I'm sorry, the second one was also in 85?
Yes.
All right. The use of this word by this man, however, continued through 1988. Isn't that correct?
It's leading. Leading.
Oh, thank you. Let me ask it another way. Thank you. Were there times after 1985, in the course of these interviews that you had with Mr. Furman, that he continued to use this word?
Yes.
And how long did it continue to go on? Over. You may answer.
In the transcripts through 1988,
All right, thank you. Now, I think you've already explained to us that the last interview was in July of 1994.
that's correct.
After this case had occurred, is that correct?
Correct.
Now, with regard to yesterday, just briefly, we talked about the fact that you'd inadvertently taped over the first tape and also maybe number 9. Is that correct?
Correct.
The transcripts that we talked about, had the transcripts been made before the tapes were inadvertently taped over?
Yes.
Right. So you completed your process of doing the transcripts before you then taped over the actual tapes. Is that correct?
That's correct.
Now, in these interviews that you conducted with Mr. Furman, did you ever at any time ask him to embellish or enhance what he was telling you? Oh.
No.
In fact, what did you tell him in that regard, if anything? Oh.
I told him that I wanted realistic scenarios and responses to what may happen relative to the development of the story and characters.
And in talking to you, did he relate his own personal experiences as a police officer?
Sustained.
Well, in talking to you, can you describe what he did with regard to his personal experiences as a police officer?
Sustained.
You were talking to this man because he was a police officer, isn't that correct?
That's correct.
And why did you want to talk to him?
Has been.
All right. In addition to talking to Mark Furman, did you talk to other police officers in and around this same time?
Yes, I did. Approximately 15.
15 police officers?
Yes.
Did you go to the police academy?
Yes, I went to the Los Angeles Police Academy and talked with physical training, people who worked with cadet patrol women there. And I went on ride-alongs and talked with other police officers as well.
And why did you do these? Why did you do these things?
It was important to balance my understanding of the frustrations, as I mentioned before, that the women were feeling, the reasons why they wanted to become officers, and some of the obstacles that they faced, the very real obstacles that they faced on the force, and with dealing with some men who might belong to a group, Men Against Women, who didn't want them to be officers. I needed to have a clear understanding of the realistic kinds of obstacles they would face.
All right. Now, we mentioned that these N-word references were between 85 and 88. Did you have any interviews with this man between 88 and 94 that were taped?
Yes.
And how many? If you recall.
Between 4 and 6.
All right, they were less than had been before in 85 and 86 and 87 and 88.
Again, please.
Well, the frequency of the interviews, did they become less after about 1988?
Yes, they did.
And was there a period of time when there were no interviews, a year or so when there were no interviews?
No taped interviews,
No
that's
taped
correct.
interviews? And when was that?
During the early 90s, there were few taped interviews.
All right. Now, yesterday you had shared with us and with this jury that when Detective Furman used this word, this offensive word, the N-word, he seemed to speak in an ordinary speech or something of that nature. Do you recall that?
Yes.
And would you describe for the jury what you meant by that?
Objection, asked and answered.
No.
Sustained. Sustained. Was asked yesterday.
To explain it, Your Honor?
Yes.
All right. May I have just a second, Your Honor? Thank you. Your Honor, nothing further at this point.
Mr. Darden?
Good morning, Mr. Darden.
It is true that you and I have met before, correct?
That's true, yes.
You, your husband, your attorneys, Ms. Clark, Ms. Lewis, Mr. Hodgman, and myself, we all met on August 17, I believe, in the DA's office. Is that correct?
Yes, I believe that was the date.
Okay, that's August 17, 1995.
Yes.
Okay. And we had a discussion about the transcripts and tapes and epithets that you described here today and yesterday, right?
Yes.
Okay. And it is a fact, isn't it? That is that Mark Furman used these epithets in 1985, correct?
Yes.
And in 1988, correct?
Yes.
You know, the two gentlemen seated here behind me, who are these two gentlemen?
Mr. Ron Regwan, Mr. Matthew Schwartz, they're my attorneys.
Okay. And they are entertainment attorneys?
Object, Your Honor, this is relevant material.
Sustained.
You told us a little while ago that the tapes and transcripts were not for sale. Is that correct?
That's correct.
May I re-ask that
I think she answered the question.
they are entertainment lawyers?
Objection, Your Honor. Your Honor,
Sustained.
Isn't it true that Mr. Redwan and Mr. Schwartz have been attempting to sell those transcripts and those tapes?
Objection, Your Honor. Attorney-client privilege.
Overruled.
I object, Your Honor, also.
Overruled.
I can answer the question?
You can answer the question.
The question is, isn't it true that they have been attempting to sell those tapes and transcripts?
Yes.
Yes. No, that's not true.
Okay. I'd like to show you. May I have a moment to confer with counsel?
Yes.
Have you been attempting to sell any audio tapes other than the Furman audio tapes?
No.
Okay. Have you been attempting to sell any transcripts other than the transcripts of the Furman audio tapes?
That question is vague to me. Could you rephrase it? It makes it sound like I'm attempting to sell the tapes and transcripts, and I'm not. So I'd appreciate it if you'd rephrase it.
What's next in order?
I'm sorry, 603? People 603.
I have a 4-page document. It's dated August 18, 1995. It is entitled Non-Disclosure Agreement. It is on the letterhead of Regwan and Schwartz in their law offices. May I approach the witness, Your Honor?
You may.
And may I remain for a few moments?
Yes, you may.
Let me show you what has been marked. People 603, please. You can take it. Is that document entitled Non-Disclosure Agreement?
Yes.
Is it on your attorney's letterhead?
Yes, it is.
Is it dated August 18, 1995?
That's correct.
And you are their client?
I am.
And paragraph 2 in that document, does it read as follows?
I object, Your Honor, for the foundation with regard to this witness and this document.
Sustained.
That document is addressed to Dove Publishing, is that correct?
That's correct.
To the publisher himself, Mr. Wiener?
I don't know that he's the publisher. It's addressed to Mr. Michael Wiener, yes.
Were the tapes, the Furman tapes, submitted to Michael Wiener at Dove Publishing?
No, they were not.
Is there an attempt to submit them to him?
Not to my knowledge, no.
Look at the last page of that document, if you will. Is there a signature at the last page?
Yes, there is.
Okay. And can you read that signature?
It's Ron Regwan.
Now, if you could turn back to the first page, please. Does the document contain the term?
I object. There's no foundation. This is
Sustained.
never seen.
Sustained. Foundation.
Have you ever spoken with Inside Edition?
Have I ever spoken with Inside Edition?
Yes.
Could you define what Inside Edition is? Is that a tabloid or television show, newspaper, periodical?
You're not familiar with the term Inside Edition?
I've heard the term, yes. I've heard.
Wait. Overruled.
I have heard Inside Edition, but I would like you to define it for me, please, so I'm clear in my response.
It is a television program. Have you ever spoken to any representative from Inside Edition, the television program?
No, I have not.
When did you bring those tapes to California? Do you recall the date?
When we were subpoenaed, we flew to California on July 13th, 1995, and my husband and I brought the tapes and gave them to the court.
Now, the document in your hand, you've never seen that document?
No,
Did you authorize your attorneys to sell the transcript?
no,
Did you authorize them to sell the audio tapes?
no,
Have you ever discussed with anyone selling the audio tapes for $500,000?
Have I discussed that with anyone?
Yes.
No, I have not discussed it with anyone.
Have you given your attorneys the authority to negotiate for the sale of the Furman tapes?
I've authorized my attorneys to determine the value of the tapes, yes.
Okay. And is that what that document relates to then?
Objection. There's also speculation.
You can answer the question.
Thank you. I would assume, although I have never seen this document, that that's what this relates to. It's a non-disclosure agreement.
Doesn't the document say that the tapes are submitted so that Dove Publishing can decide whether or not they want to purchase?
Sustain. Sustain.
The witness.
Sustain.
Is it indicated anywhere on that document that the tapes are being submitted to Dove Publishing so that Dove Publishing can help you ascertain the market value of the Furman tapes?
No objection to one of the questions. You've never seen the document.
Would you ask the question again, please?
Where, if anywhere, on that document does it indicate that the Furman tapes are being submitted to a publisher so that the publisher can help you determine the market value of those tapes?
I object to one of that question. That's argumentative.
Firstly, I have never read this document. I've never seen it. I would have to read it to be able to answer that question clearly. And the tapes and transcripts were never submitted to Dove Publishing. They have only been given to the prosecution and the defense.
If you weren't interested in selling the tapes, why then did you meet and confer with others
Object.
to determine the market value of the tapes?
Object to one of the
Again, please, then?
The question is this: if you weren't interested in selling those tapes and transcripts, why then did you have your attorneys go out and attempt to submit them to publishers to determine the market value?
Sustain.
The document.
Sustain. Rephrase the question.
If you weren't interested in selling the tapes, why did you have your attorneys contact a publisher?
It's important to know what the value of the tapes are. And I authorized my attorneys to do that.
And that's because you were considering selling the tapes at the time?
No, I wanted to know what the value of the tapes were, and my attorneys advised me that it was in my best interest and they would be negligent as attorneys if they didn't let me know exactly what the value, market value of the tapes or the transcripts would be. Keep in mind, I've had a great deal of material leaked, and that's an aspect that I would certainly want to be considering.
In addition to attempting to determine the market value of the tapes, you also had your attorneys attempt to determine the market value of your transcripts of the tapes as well. Is that correct?
That would be correct, yes. I thought that's what this document was in reference to, certain transcripts. I believe you have highlighted in yellow.
Was it your testimony yesterday that you were offended when you heard Mark Furman use that epithet?
Yes.
Now, when you met with Ms. Clark and Ms. Lewis and Mr. Hodgman and myself on August 17th, do you recall me asking you what you thought or what came to mind when you first heard Furman use that epithet?
Yes, I do.
And you told me that nothing came to mind. Is that correct?
That's correct. That I couldn't remember anything coming to mind the first time. Your question was what came to mind the first time you heard that word, I believe.
But you couldn't remember what came to mind at the time.
No, that would have been about 10 years ago. I could not remember the first time I heard that word used, what came to my mind.
You couldn't remember a white police officer using this epithet in your presence and you're not being offended by it?
Object to the form of that question.
Sustain. It's argumentative.
You understand if that word is the most vile word in the English language?
I think it's one of the most vile words in the English language, yes.
You think they're worse?
Yes, I certainly do. Why are we having this adversarial relationship? I don't understand that. It's a vile word. Why do I have to define it more so than it is?
You wrote a screenplay, right?
That's accurate.
Did you use that word in the screenplay?
Yes,
Did you attempt to go out and sell that screenplay?
certainly.
You're using that word in your screenplay to help make money, right?
Object on that question.
Sustained. Sustained.
Are you trying to make money off of the use of that word?
Object on this question.
Overruled.
Object.
Overruled. It's an appropriate question.
When you met Detective Furman, you told him that you were a screenwriter?
That's accurate.
And you told him that you had written other screenplays?
Yes.
And how many screenplays have you written up to this point?
I've written about a dozen screenplays, approximately 6 that I would consider that would be in appropriate shape now to be read, but I've written about a dozen screenplays, more treatments, synopses.
And how many screenplays did you tell Furman you had written when you first met him?
Well, it seems the fact now that she told me.
Sustained.
Did you tell Detective Furman how many screenplays you had written when you first met him?
I don't recall telling him how many screenplays I had written, but it could have come up in conversation that I had the year before won an award for a screenplay through the Writers Guild of America East Foundation. That could have come up.
Do you have to be a member of the Writers Guild to win that award?
No, you don't.
Are you a member of the Writers Guild?
No, I'm not.
You've had one screenplay published or made into a film?
Have I had one screenplay made into a film?
Yes.
No.
Have you had any made into a film?
I have had short pieces filmed, yes.
Okay. You had a short piece called The Painter?
Yes, I did.
Okay. And who made that into a film?
That was produced by Playboy Productions.
And who directed that film?
Daniel McKinny.
Your husband?
That's correct.
And this piece was what, a sort of soft porn kind of a piece?
Sustained. This is not relevant. This is not relevant.
When Mark Furman used these words in your presence, why didn't you just tell him to stop?
Well, I object on that question. Object on that question.
Overruled.
Are you having?
Overruled.
For the same reason, I didn't tell him to stop when he told me of police procedures, cover-ups, other information that I felt were important for me to have a clear understanding and context of this material that I was writing. He told me many things that I thought were important for me to understand, many things I hadn't been aware of, as did other officers of the Los Angeles Police Department, as did many of the other interviews that I did and ride-alongs I went on. I was in a journalistic mode. I was not judgmental, and I needed that information to help me write a more realistic journalistic piece. And I did not ask him to stop using the type of normal, ordinary language he would use or other officers would use. I needed to know how he would speak.
You told us yesterday that there was no racial subplot to the screenplay you were planning to write, correct?
And that's accurate.
And yet you used this epithet in your screenplay anyway. Is that also correct?
That's true.
Now, your relationship in 1985 with Mark Furman, was it only professional?
Object, Johnson. I'll over the chair.
Overruled.
It was a business relationship. He was a technical advisor for the screenplay.
And that is it?
Yes.
About cover-ups a few minutes ago. Is that right?
I'm sorry, again, please.
Did you mention the term cover-up a few minutes ago?
I did, yes.
And what you were alluding to at that time was a discussion you and Furman had as it related to women police officers. Is that correct?
You object on that question. Are you having?
Is that correct?
Again, please, I'm sorry.
And what you were alluding to was a conversation you had with Detective Furman as it related to female police officers and the LAPD's recognition that female police officers did not perform well in violent situations. Is that right?
Object to form that question. Overruled.
Some LAPD officers, and also in relation to police procedural cover-up issues that I needed to know about.
You spoke to us on August 17. Can I have one moment? When I look through this, let's strike that. I'd like to bring Mr. Cochran a clean copy of this document, Your Honor.
Why don't you show it to him? Do you recall during our August 17 interview that Ms. Clark asked you specifically what you meant when you used the term cover-ups?
No object to form that, Your Honor.
Overruled.
Yeah, I do. Yes, I do remember us discussing that.
Okay, and do you recall her, strike that, and do you recall telling her that what you were referring to were cover-ups in terms of the LAPD's recognition and cover-up of the fact that female officers did not perform well in violent situations, or words to that effect?
I don't know if it was Miss Clark or Miss Lewis who made that comment. It was one of them.
Okay. But that was basically your response to them at the time?
Yes.
Okay. Now, you asked a moment ago why we're involved in some adversarial relationship. Do you recall asking that?
I felt that you were. I don't feel adversarial towards you, but I felt that there was something negative coming from some of your questions, yes.
Okay. You didn't stop him the first time he used the epithet,
Your Honor, that's
correct?
It has.
Okay. Well, you didn't stop him the 20th time he used the epithet,
Asking this?
That has not. Overruled.
correct?
That's correct.
And you didn't ask him the 40th or 42nd time that he used the epithet, correct?
I didn't abridge his dialogue or conversation during an interview, no.
Given the fact that you've included this epithet in your screenplay, do you feel that it's appropriate under some circumstances to utter or use this word?
No object to form this.
Overruled.
Form that question.
Overruled.
Do I personally feel it's appropriate?
Yes.
No, I don't.
Why then include it in a screenplay that you intend to make into a movie?
Because it's reflective of a particular officer's or officers' dialogue, feelings at a particular time. It's representative of what would be said.
That's all I have.
Mr. Cochran?
Ms. McKinney,
Yes.
you don't like racism, do you?
No.
But you understand that racism exists in the world. Are you aware of that?
Yes, I'm aware of that.
And the fact,
Excuse me, these are argumentative and leading. Proceed.
the fact that Mark Furman used the N-word more than 42 times.
Overruled.
That make you agree with him when he's using those words? Did you agree with him when he was using those words in that base, vile manner?
Of course not.
You've described for us that you were working as a journalist at the time. Is that correct?
That's true.
And with regard to your screenplay, Men Against Women, you told us yesterday that racism was not one of the, not even a subplot. Is that correct?
Overruled.
Is that correct?
That's true.
And so when these words, these vile, insulting words came up, you weren't saying these words, were you?
No,
Who was saying these words?
Officer Furman.
Who was expressing these views of cover-ups?
Officer Furman.
And with regard to this cover-up,
Overruled.
with regard to cover-up, he talked to you, did he not, about...
Sustain. Sustain.
Well,
Sustain.
well, Your Honor, I need to be heard.
Sidebar.
Certainly do.
Step back in the jury room, please. All right, back on the record in the Simpson matter. All parties are again present. Jury is not present. Mr. Cochran, did you want to make any further comment on your...
Would the court allow Uelmen to make that point?
We're in mid-sentence in your argument, counsel.
But I would ask that he make, because it ties in with...
No, I prefer that you conclude the...
Madam Secretary.
Sir. Mr. Darden? Yes. Mine is not time-stamped on the side. Mr. Cochran?
Thank you very kindly, Your Honor, for this opportunity. What I wanted to indicate to the court, and I'll do it as briefly as possible, is that I believe that my colleague, Mr. Darden, opened the door when the testimony was elicited about a cover-up. Further, I think you have to, first of all, look at the thrust of their cross-examination. The impression they gave to this jury was that Ms. McKinny was in some way trying to profit from these tapes, profit from the transcripts, and nothing could be further from the truth. I need hardly remind this court that we got Your Honor to issue a subpoena, that I went to North Carolina, and we were rebuffed at the Superior Court, or the comparable court to the Superior Court. We had to go all the way to the North Carolina Court of Appeals, and these lawyers, Messrs. Regwan and Swartz, did an excellent job in fighting us to get this. She resisted coming to California. When she finally got here August 13th, you saw the problems we had even getting the tapes then.
No, I'm familiar with the history. Is that where you're going with this?
Well, yeah. I think they've opened the door clearly to that. But in addition, other than that, Your Honor, in addition to that, so that's the impression they give to this jury. She doesn't want to be out here. She didn't favor one side or the other. You'll recall that when we were in court that day, I'll get to the point, Mr. Simpson. You'll recall. Usually I'm sitting next to them when we talk about that, you know.
I know I can hear most of it.
Saying understand. You will recall that when we argued about the tapes belonging to the defense, or at least we had the right to it, she went down that same day, she and her lawyers, and gave a copy to the prosecution. She went in and talked to them. They interviewed her for hours. And that's why she was so taken aback by what she perceived as negativity. Now, with regard to what they've done here, you last week, Your Honor, and I know you don't like to ever be quoted, but this is time I think I can quote you appropriately, that you had said last week that it was clear to you that after listening to the tapes, it was clear that Furman wasn't describing a fictional character, but was describing his point of view. And I mean, everybody in the world knows that. Now, if that's true, these tapes are the best evidence. What they're trying to make it seem like she's trying to embellish this, that she gets these things out with Michael Wiener. A non-disclosure agreement is to test the water. Wiener or his office never, ever saw these tapes or transcripts. That should be abundantly clear. I can bring that out also. The lawyers felt it was malpractice not to know the overall value of these things. Now,
all right, Mr. Cochran, let me just cut to the chase here. The issue that I was concerned, I agree with you that it's probably appropriate redirect to go back and discuss the procedural fight to get those tapes, and that Ms. McKinney resisted all the way to the appellate courts in North Carolina, and that once she was compelled to come here to the state of California, then she cooperated with both sides. I don't have a problem with that.
Right.
I could probably do that in 5 questions.
okay, well,
All right.
we'll see if we
Second
can do
issue,
that.
the issue about selling the tapes, or I'm sure Ms. McKinney's had the opportunity to discuss with her lawyers the fact that the tapes and transcripts were never transmitted to Dove Audio to anybody else for commercial exploitation purposes. That's fair game because that's an issue that was brought up. I'm more concerned about the issue that was our last sidebar.
Let me address that, Your Honor. I think that clearly, when Mr. Darden got the answer about a cover-up and cover-ups, he then went back, as he indicated, to try and repair the damage, in his own words. And what he did was try to elicit from her, well, you were just talking about, when you talked about cover-up, that the LAPD covering up men against women and that sort of thing. That's not correct at all. And this witness will say as an offer of proof that, first of all, there were many cover-ups, as you know from the tapes. There were cover-ups from the very beginning, when officers would go out and they didn't have probable cause to arrest anybody and tear up their driver's license. There's cover-ups and manufacturing evidence all throughout. But specifically with regard to men against women, in the instance, you recall...
I think that my recollection of Ms. McKinney's transcripts is when she talks about cover-ups, she talked about it in terms of, she used the term cover-up in the terms of a incident of police misconduct having occurred and then there being a concerted effort by the officer involved to make sure that nobody was disciplined. For example, my recollection of the plot was that one of the female officers was supposed to have arrested somebody, then the transporting officers then beat the arrestee out of her presence.
Ruptured the spleen.
Ruptures the spleen with the batons, and then she comes in and says, I didn't see any of that, I don't know who transported, et cetera, and becomes part of it. That was my understanding of her discussion of cover-ups.
Right. Well, you're right on with regard to that. It's much more than what he's elicited, and clearly he's opened the door on that. It's about a cover-up where, to be one of the boys, this female then covers up the death of a suspect whom she's choked out, but she doesn't kill the suspect. The suspect is killed by these other male officers who beat this person to death by rupturing spleen. Actually, and that's not fictional, by the way, as this community is going to find out. But the other issue, Your Honor, is this: that she talks about other cover-ups also. I mean, she talks about cover-ups all the way through. So what I'm saying, you can't just limit it to this instance of the men against women situation. They open the door.
Which hence brings me to my question: where are you going? What specific instances are you going to?
I'd like to ask her, well, let me tell you the question I'd like to ask then, Your Honor, specifically. I'd like to ask her, what did you mean when you said cover-up? And I think she'll then tell you what she means in the men against women context, but also in the other contexts where Detective Furman talked about covering up, and the court can ask her. I mean, I'm not testifying. She'd be the one so indicating, and I think we're permitted to do it. After that, and the final thing I'll say on this was, I think they've opened the door by virtue of the fact that this attack on this witness, this unnecessary, needless attack, and you told them about not going into this, and yet they did it. When they did that, they've opened the door to these tapes, and I think now we get a chance to do that. Now, you know, for instance, Mr. Darden's questions about as though she was egging Furman on, using racial epithets, or you didn't try to stop him, or whatever. That's almost as though you would say that when they wrote Roots, and they used the N-word in Roots, that you couldn't talk about racism. Judge, this play is about sexism. This lady is opposed to sexism. And in literary circles, in art, that's how you address things. So people start to discuss it and maybe bring about some changes. I mean, you don't buy into it necessarily. And so now that's been done. This door has been opened. It seems to me that we should be permitted to do this. And that's why, you know, I wanted to make this statement to the court. Certainly you cleared the first part of it, but I think the rest of it is also clear, Your Honor. I'm being handed something. May I read something to the court my counsel just shared with me, Your Honor? This has to do with, let me just read this, and I think it puts it in perspective about lying and covering up. This was our number 10, describing the necessity for police officers to be willing to lie. Well, I really love being a policeman when I can be a policeman. It's like my partner now. He's so hung up with the rules and stuff. I get pissed.
He's got more morals than he's got hair.
Remember that. You just don't fucking even understand. The job is not rules. This is a feeling. Fuck the rules. We'll make them up later. He's a college graduate, as you know, a Catholic college, etc. He was going to be a priest, etc., and he's got more morals than he's got hair. What do you mean he's got more morals? He doesn't know how to be a policeman. Whispers. I can't lie. Oh, you make me fucking sick to my guts. You know. You do what you have to do to put these fucking assholes in jail. If you don't, you fucking get out of the fucking game. He just wants to be one of the boys. Doesn't want to pay the dues. So how does he deal with it? He doesn't lie. Well, I know for a fact in this internal affairs investigation, he has a 10-day suspension. He'll roll. He goes on to say, he'll drop a dime on me, he'll squeal. Now, Judge, that is cover-up. And that's another cover-up. And clearly, I think you understand that. And that's the point that we're trying to make. We are now permitted to at least play this to the jury, to at least ask questions about it. He can't talk about cover-ups and then try to put it in this little tiny frame that he was only talking about men against women, because that's not even clear. We can clear that up, plus show, I think, is a representation to this court that there are other instances of cover-up. And they opened the door. You ruled. We all understood that. But they've opened the door, Judge. So I'm asking you to allow us to do this, and let's get it on with, if we can finish our case. They've opened the door. And also, you know, one of the other issues that we're going to be talking about is cover-ups raid probable cause, lying to try and put together probable cause. But that's another issue. But I think that this is a very germane thing. We sat over there. It's now happened, and it seems to me we should be permitted to do this, Judge.
Mr. Darden.
Your Honor, at 10:14 and 44 seconds, I asked this question. When Mark Furman used these words in your presence, why didn't you just tell him to stop? And after an objection, Ms. McKinney volunteered for the same reason I didn't tell him to stop when he told me of police procedures, cover-ups, and other information, and so on and so on. So I didn't invite this witness to bring the term cover-ups into these proceedings or into her testimony, Judge. I asked her about a specific word. We were talking about a specific epithet, but she brought it in. And yes, I did attempt to repair some of the damage. And so now the issue before the court is, now that the witness has volunteered this, does that now allow counsel? And by the way, Ms. McKinney is his witness, not the prosecution's witness. Does that now allow counsel to drag in more inflammatory and irrelevant material before this jury? I don't think so. I don't think that's fair. I don't think it has any probative value at all. And what I was attempting to show the witness was an excerpt from a transcript of a conversation she and I had on August 17 in my office. And if I could just read into the record briefly what that excerpt says. And this is Ms. McKinney at page 5, line 19. He expressed very strongly that it would be wonderful if someone would write a story from his point of view, from the men's point of view, about why women weren't succeeding in those areas and what they couldn't do and what kind of cover-ups were occurring in terms of that. And that interested me. Okay. So even my subsequent follow-up questions were directed to Mark Furman's belief that the department was covering up the fact that female officers did not perform well in violent situations. Okay, I wasn't getting into all this other stuff, and you know, Mark Furman did discuss other kinds of cover-ups and other issues like that in his taped interviews with Ms. McKinney, and I concede that, and we've conceded all of this all along. But my point today is this. Well, it's a personal point of view. At any event, I don't think this opens the door to any of this. I think it's time to take control, again, of these proceedings, and let's move along with the issues that are relevant.
May I respond, Your Honor? Your Honor, certainly, Your Honor, thank you. This, Your Honor, is about their attack on her credibility. And the court has said many times, been very concerned many times about leaving an unfair, a misleading impression upon this jury. You told the prosecution last week how they should conduct this cross-examination. What Mr. Darden did was he asked the famous why question.
I offered them some advice.
Well, yeah, well, I didn't mean in a
As I oftentimes offer you
for both
advice.
sides, yes. But you made a suggestion. They didn't follow it. They asked the why question. That this answer that he got, and then he went into it further in cover-up. And when he does that, there's much more to it than that, and it's wrong. And they attacked her credibility, Judge, and you've heard those tapes, and that's unfair. That's a misleading impression to this jury. And they're using your ruling as a shield. They're turning the shield as a sword against us and against Mr. Simpson specifically. And so that's not right, Your Honor. We have a right, it seems to me, under these circumstances, to plumb this area, to bring out what you deem appropriate in this area. And we're not going to belabor it, but we have an absolute right. They opened the door. I mean, this isn't anything we did. We did our examination, sat down. We're back up here now because of something they did, and I think we have a right to do that. In the interest of justice and truth, we have a right to do that. Also, in the interest of a lady who fought getting out here, to malign her in front of this jury and give that wrong impression is not right. And so I think the court would want to at least allow us to straighten that out on each of these areas and to point out there's more to this cover-up regarding men against women, but also there are other cover-ups that she was talking about. And I think when you ask why questions, you get those answers, Your Honor, and that's the thing. That's the point that comes about. And I think that the record is very clear in this regard, and I ask the court to rule and allow us to do it, and you said 5 questions in there, we'll be very quick. I'll try to do the whole thing in 10 or 15 questions. In fact, I'll take your advice if you want to give me some of that.
All right, thank you, counsel. All right, as to the questioning regarding the procedural history as to how the tapes and transcripts got to California, and the fact that Ms. McKinney did resist through the appellate courts in the North Carolina courts, that is an appropriate line of questioning. As to the discussions regarding Dove Audio and the nature of that agreement, that is appropriate redirect examination based upon the cross-examination. As to the mention of cover-ups, the problem I have here is that the answer where Ms. McKinney mentions cover-ups was a non-responsive answer. The question was concerning tolerating the use of the N-word, or at least not mentioning it in response to the use, not making any mention in response to the use, and then adding gratuitously the issue regarding cover-ups. However, it is raised in the context of a specific statement by Ms. McKinney made to the district attorneys. That statement has been made available to the defense. Mr. Cochran, you may redirect your examination as to that statement made to the district attorney's office. All right, but that is the limitation.
All right, and so that I'm clear, I can plumb that particular area as to what you meant by cover-up in that area, is that right?
That particular area about men against women,
Okay.
inadequacies of women police officers,
All right.
alleged. All right, let's have the jury, please. All right, the record should reflect that we've been rejoined by all the members of our jury panel. And Mr. Cochran, you may continue with your redirect examination.
Thank you very kindly, Your Honor. Morning again, ladies and gentlemen. Good morning, Ms. McKinney.
Good morning,
might
Mr.
continue
Cochran.
on. Ms. McKinney, you had shared with us, in fact, I think on cross-examination you said that you've been out here since July 13th. Was that correct? Was it July 13th?
No, it wasn't correct.
What's the correct date?
August 13th.
It may just seem like July 13th. Is that it? But you've been here since August 13th?
It's been a long time.
All right. And is your family here with you?
Yes, my husband and boys are here.
Now, ma'am, with regard to you're coming to California. Did you voluntarily come out here and bring your tapes and transcripts out here so you could come to California and testify?
No, sir, I was subpoenaed by the court.
All right. And when you were subpoenaed by a subpoena issued by Judge Ito in this court, did you resist and fight that subpoena?
Yes, I did.
And tell the court and jury what you did to fight that subpoena.
I hired Mr. Regwan and Mr. Schwartz, and they...
Two gentlemen seated there,
Two
ma'am?
gentlemen seated there, and they flew to North Carolina and fought the subpoena in court there with Mr. Cochran and Mr. Bailey.
So in other words, you first met me in North Carolina about a month ago, is that right?
That's correct.
And you fought this subpoena at that time, isn't that correct? Winston-Salem, North Carolina?
Yes,
In fact, you won in the initial hearing, isn't that correct?
my attorneys did, as well as a local firm with whom they were working.
All right, and thereafter,
Mr. Cochran, I think there's an impression here. You said that you were in North Carolina. I think needs to be made clear to the jury that you were on one side and Mr. Regwan and Mr. Schwartz were on the other side.
Yes, Your Honor.
At that time.
Thank you, Rick. When we were in Winston-Salem, North Carolina, on a Friday morning, you had your two fine lawyers, Messrs. Regwan and Schwartz, right?
That's correct.
Plus local counsel there in Winston-Salem,
Yes.
right? And on the other side was myself, Mr. Bailey, and our local North Carolina counsel. Is that correct?
That's correct.
All right. And then at that point, the judge in North Carolina ruled for you, so you wouldn't have to come to California. Isn't that right?
That's correct.
And then we continued to fight this matter, and it went up to the North Carolina Court of Appeals. Isn't that right?
That's right.
And that's where we won at that point. Is that right? By we, I mean Mr. Simpson's side won at that point.
That's correct.
And I presume nobody was reimbursing you for the money you were spending. Lawyers aren't free, are they?
Objection, irrelevant.
Well, nobody was, in other words, nobody was helping you pay for these lawyers you had back there, were you?
No.
And at some point, when the North Carolina Court of Appeals upheld Judge Ito's subpoena, you then agreed to come to California. Is that correct?
I don't believe I had a choice. Certainly I would.
Right. In other words, when the final court ruled, you then came to California. Is that
Yes.
right? And that was only after then when you produced and delivered these tapes. Is that correct?
That's correct.
All right. And once you came to California with these tapes and these transcripts, the same date that you delivered them to the defense, Mr. Simpson, you also delivered them to the prosecution on that same day, did you not?
That's correct.
And you tried to cooperate with them, didn't you?
I've wanted to cooperate with the court, the prosecution, and the defense, yes.
In fact, Mr. Darden asked you that if you came to California on August 13th, was it August 17th, as he asked, that you came down in this building in the DA's office and met with all the DAs and talked to them, isn't that right?
That's right.
And in that meeting, they tape recorded everything you had to say, didn't they?
They did.
And you also gave them a copy of your screenplay, didn't you?
Yes, I did.
You cooperated fully, right?
Yes.
Now, with regard to your work as a screenwriter, you described for Mr. Darden that you'd won an award at some time in the past through the Writers Guild of America. Tell the jury about that award and whether or not there was a cash stipend that went along with that award.
Objection, irrelevant.
Or you may
Ask
answer.
the question.
Yes, it was an award I won in 1984 through the Writers Guild of America East Foundation. So it's a competitive award for original screenplays. And there was a cash stipend, and along with that, a request that you write another screenplay with a mentor of your choice. The cash stipend I used to purchase a computer and my laptop.
All right, and you've done other screenplays in addition to this one, Men Against Women, isn't that correct?
That's correct.
Now, you've shared with us in this jury that the premise of Men Against Women is sexism, is that correct?
Yes.
And are you opposed to sexism?
Yes,
Yet you write a play about sexism, right?
that's correct.
And would you describe for the jury why, as a writer, you write a play about sexism?
It's a topic I wanted to explore from the man's point of view and a woman's point of view to try to understand better why some men would be so upset by what they felt as the incapable abilities of some women in areas of high crime that they would form an organization called Men Against Women and be a part of that, and why some women would be upset with some of the things that men were doing and making it difficult for them to perform their jobs, embarrassing them or humiliating them. So I wanted to try to to explore those issues and develop some kind of a dialogue or discussion.
Now, I'd asked you a question before with regard to the whole concept of racism and writings regarding racism. During the time that you, 1985, when you first encountered this man, Mark Furman, you described for us, I believe, that you were employed at UCLA working with Terry Donahue. Is that correct?
I was employed at UCLA working under the auspices of Coach Terry Donahue in conjunction with the College of Letters and Sciences.
All right.
Yes.
And in that connection, did you work frequently with African American athletes?
Yes, I did.
Would you describe for the court what you did during that time and the jury?
The the NAA, the National Association,
NAACP?
No, not the NAACP, it's the college.
NC2A?
Yes, NC2A, thank you very much.
Those alphabet organization, okay.
Right.
NC2A,
Yes.
okay.
Had demanded that athletes be studying courses in their field of expertise and not taking any class. So it was incumbent upon the athletic department during that period to hire educators who they felt would be able to work with athletes who were high-risk athletes that they felt might need extra counseling, extra tutorial time, and extra times of understanding time management and study skills. So they would hire someone such as myself to work with what they called high-risk athletes, and that's what I did during that time.
And would some of these high-risk athletes be African-American youngsters?
In the beginning, they were, yes.
And did you interact with them on a daily basis?
Yes,
Do you enjoy that work?
very much.
Now, you were asked some questions about a document that Mr. Darden marked, and at the top of it is called Non-Disclosure Agreement. May I approach you?
You may.
And do you know what a non-disclosure agreement is, Ms. McKinny? Generally?
Generally, I do.
And what is it?
I've just recently learned non-disclosure. It's an agreement that you would give to another party, and what it does is ask them not to discuss the material, not to show the material, not to copy the material. They cannot disclose or talk about the product or the material to anyone else.
As I
Is
understand
that
it-
accurate? That's my
I think-
understanding.
I think so. As I understand, the letter that I placed before you, August 18th, 1995, from Mr. Michael Wiener, addressed to Michael Wiener from your lawyers, you had never seen that before Mr. Darden showed it to you. Is that correct?
That's true.
And with regard to, since you came to California, have you at any time ever authorized anyone to try and sell these tapes or screenplay? Strike that. These tapes or transcriptions.
No.
All right. And with regard to your lawyers, did they at some point tell you that would be malpractice if they didn't try to find out for you what the value of these tapes and transcriptions were? They tell you that?
Yes, they did.
And did they try to find out the value of these tapes and transcriptions?
Yes.
All right, Mr. Cochran, do you need to stand there
No,
because
no.
you're blocking juror number 7 there?
Thank you. Now, thank you. Now, in that connection, even though you've now found out the value of these items, and I won't ask you what the value is, you still have not tried to sell these, have you?
No, I have not.
What you do want to sell is your screenplay, Men Against Women, isn't that right?
Yes, that would be lovely.
That's what you want to do, isn't that right?
Yes.
All right. Now, ma'am, you mentioned in response to one of Mr. Darden's questions about specific cover-up as relates men against women. And I want to ask you In that regard, what did you mean when you talked about cover-up as relates to men against women in this screenplay that you ultimately wrote? Can you tell us about that?
Yes. One of the reasons why I was discovering that some women were having a difficult time being accepted into the police department in certain male circles.
Being responsible.
Overruled.
You may continue, ma'am.
In certain male circles was that some officers didn't trust their confidentiality, their ability.
All right, next question. Next question.
Well, can you continue and tell us, can you answer the question, please?
Okay.
It is turning into a narrative once you ask the next question, Counsel.
All right, sure. When Mr. Darden asked you about this cover-up as relates men against women, can you succinctly state for this jury what you meant and what you had reference to?
Yes.
I'm going to object. I'm going with that question.
Overruled. Go ahead and answer the question.
Some women on the police department were not willing to follow the...
No, overruled. Answer the question, Ms. McKinney, please.
Some women on the police department were not willing to adhere to some of the cover-ups that men were...
Ask another question.
Well, you said that some women on the police department were not willing to hear.
Your Honor, may we approach, please?
This is not the topic, Counsel. Let's redirect it back into that topic.
All right, Your Honor. With regard to this subject of cover-up, can you tell us what you had reference to, specifically in the area that Mr. Darden asked you about cover-ups as relates to women and men on the Los Angeles Police Department?
Objection. The question is vague. 352.
Ms. McKinney, we're speaking about the specific topic about the controversy about women as police officers in areas of high violence or high crime, the topic of your book.
Right.
Yes.
Okay. That's the sexism issue that relates to why women were unable to cover up some issues the same way men were, and it's related.
Objection,
They're
Judge.
interchangeable. They're interchangeable. Sexism was what I was looking into, but what I found out was related to cover-ups that men were purporting.
Overruled.
I couldn't get the last answer.
Finish the question.
Finish
the
the
answer.
answer, please.
Sexism was the issue that interested me. It was what I was looking into. But what I was finding is that
Overruled.
what I was finding was that sexism is inextricably related to certain cover-ups that some men on the police department are doing, and some women are not able to agree with that or follow along those lines. And that was a huge schism between men and women.
And in that connection, can you give us like an example of this schism between men against women where there was a resulted as a result of cover-up?
352, Your Honor.
Sustained. Sustained. We've covered it.
I want to ask another question in this regard, Your Honor. Did Mark Furman ever explain to you why he wouldn't trust a woman in this, from a standpoint of cover-ups?
Sustained. It's not relevant.
Now, Mr. Darden asked you a lot of questions about why you didn't stop Mark Furman or using this N-word or whatever? Do you recall those questions?
Yes.
And is there any doubt in your mind now as you sit here that Mark Furman used this horrible word 41 or more times during the times that you were talking to him? Any doubt in your mind at all?
Or
No.
And those were his words coming from his mouth, is that right?
That's correct.
Those weren't your words, were they?
No.
And before I conclude, may I approach this for a moment, please?
With the court reporter, please.
Thank you.
Mr. Cochran.
Two other questions. Your Honor, when you indicated that Mr. Furman had used this word some 41 or more times, how do you know that? Did you count them yourself? From the transcripts and the tapes?
No, I did not count them.
All right, you've seen them, however, in the various and sundry documents filed with this court?
Mr. Leading.
Okay. Have you had occasion to review any documents filed with this court with regard to the use of that word?
Overruled.
Yes, I reviewed the offer of proof submitted by the defense.
Basis.
Irrelevant.
Overruled.
And you've counted those documents, right?
Yes.
All right. Now, I have nothing further at this point, Your Honor.
All right. Recross.
Ms. McKinney, you testified in North Carolina on July 30, is that correct?
I don't recall the exact date. That sounds
Would it refresh your
Close.
recollection if I showed you a transcript? I'm sorry, the date's wrong on the transcript. In any event, are you aware that the DA's office attempted to subpoena these tapes from your attorneys on July 14?
again. I don't.
Are you aware that the DA's office obtained a court order from the judge attempting to subpoena to this court these very same tapes from your attorneys on July 14?
Overruled.
No.
Are you aware that on July 10, the DA's office addressed the court and advised the court of the existence of these tapes and sought guidance from the court in terms of recovering these tapes?
On July 10th,
Yes.
again, please.
Yes.
And did what? Could you say what you did again?
And we went to Judge Ito and told him that we heard of the existence of these tapes, and we asked the court for guidance and help in obtaining these tapes and causing them to be delivered to the court.
No, I'm not. I'm not aware of that.
Just so it's clear, when was it that you authorized your attorneys to contact media entities to determine the value of the tapes and transcripts?
Object to the form of that question. There is no testimony of media entities.
Rephrase the question.
When was it that you authorized your attorneys to contact any entity or any person or any organization or any business or corporation?
I don't recall a specific date that I authorized my attorneys to do that.
Do you recall which month?
Which month?
Yes.
It would have to be July or August.
Okay. Well, do you know which one?
No, I don't.
Okay. Was there any contact with the National Enquirer?
Object to the form of
What's
that
the-
question. By whom?
By your
Rephrase
attorneys?
the question.
Did you have your attorneys contact the National Enquirer?
I don't know if my attorneys have contacted the National Enquirer. They may have. I don't know.
Okay. Did you have your attorneys contact media entities outside the United States?
I don't know. We were contacted by people I didn't even know, and my attorneys would relay that information to me. So I don't know if, for instance, the National Enquirer would have called my attorneys, or who would have contacted them.
Thank you. That's all.
Mr. Cochran.
I presume there has been a great amount of interest in these tapes and transcripts by a lot of the media. Isn't that correct?
That's correct.
But you refused steadfastly to sell these tapes. Isn't that correct?
That's correct.
And you've even sent some portions of these tapes to Mr. Mark Furman. Isn't that correct? Back in 1985 or earlier?
Yes.
Thank you very kindly. Nothing further at this particular point, Your Honor.
Mr. Darden.
Did you say, excuse me then, did,
I'm sorry. I'm
Transcript.
asking the questions.
Mr. Darden.
You said you sent tapes to
I
Mark
sent
Furman?
transcripts
Okay.
to Mr.
And
Furman.
with regard to the tapes and the transcripts, who owns those tapes and transcripts? You or Mark Furman?
I assume I own them. They're my tapes, my transcripts.
Cochran?
Just one last question. Your lawyers and you have made these tapes and these transcripts available to Mark Furman and his lawyer. Isn't that correct? Oh. Isn't that correct?
Yes, as well as to anyone else who's asked.
And the others who've asked can go to your lawyer's office and listen to these things, right?
Anyone who has standing who's
Just
asked.
some standing, like an
LA
agency or whatever.
Commission, LAPD, yes.
All right. Thank you very kindly.
If I may. The LA Police Commission has come over to take a listen to these tapes?
That my attorney's office has been available for anyone who has standing, who has called the attorneys, to listen to the tapes and take copious notes on the transcript. They have spent hours, days there taking notes. But they're under a protective order with only the prosecution and the defense actually having copies of the tapes or the transcripts.
And the United States Department of Justice, have they been there to listen to the tapes yet?
I don't know.
Has the FBI been there yet?
I don't know.
They will be, won't they?
I don't know.
That's all.
All right, Ms. McKinney, at this time, I'm going to allow you to be excused. However, you are subject to recall. All right?
Thank you, Judge.
All right, you may step down. All right, is your next witness available?
May I check and see that?
All right. Actually, once you have one of your, Mr. Douglas, check. Let me see counsel at the sidebar with the corporal.
Okay.
Cochran.
Thank you for coming, Your Honor. Our next witness is a Mr. Roderic Hodge. Mr. Hodge, will you come forward, sir? And along with his counsel, Your Honor.
All right. Mr. Cochran, why don't you retrieve the exhibit that's up on the witness stand
sorry.
first, please?
Morning, Your Honor.
Morning, counsel. Your name for the record, please?
Judge Irv Miller on behalf of Mr. Hodge.
All right. Morning, counsel. Mrs. Robertson.
Raise your right hand, please. Do you solemnly swear that the testimony you may give in the prosecution before this court should be the truth, the whole truth, and nothing but the truth, so help you God? I do. Please have a seat on the witness stand and state and spell your first and last names for the record.
First name is Roderic, R-O-D-E-R-I-C, Hodge, H-O-D-G-E.
Thank you.
Good morning, Mr. Hodge.
Morning, Mr. Cochran.
Could you move the microphone a little bit back, sir?
Just pull it close to you. Thank you.
Closer to you. Thank you. Mr. Hodge, just tell us, what city do you presently reside in?
In Dalton, Illinois.
And is that near Chicago?
Yes, it is just south of Chicago, 8 miles south of Chicago.
And have you come here today pursuant to a subpoena issued by this court from Illinois?
Yes, sir.
And how long have you been in California?
As of late, approximately 1 week.
About a week waiting to testify?
Yes, sir.
Now, what is your occupation generally, sir?
Thank you. I'm currently a communications repair technician with Flame James Communications in Chicago, Illinois.
All right. I'd like to cut through the chase and get right to it. Did you formerly live in California before you moved to Illinois?
Yes, sir.
And I'd like specifically to direct your attention back to the month of January of 1987, specifically January 11th of 1987. Did you have occasion to see or interact with a person by the name of Mark Furman?
Yes, sir, I did.
Was he a Los Angeles police officer at that point?
Yes, sir.
On that date, were you taken into custody by Mr. Furman?
I believe it was that date. Yes, sir.
All right, was it the 11th or 12th, or do you know the exact date?
I'm unable to call the exact date, sir.
All right, was it in January of 1987?
Yes, sir.
All right. And do you remember who Mr. Furman's partner was on that time?
Yes, sir. It was Vitriano. I just refer to him as Vitriano. I believe it was Tom Vitriano.
Tom Vetrano?
Yes, sir.
All right. And at some point, were you placed inside of a police vehicle?
Yes, sir, I was.
And after you were placed inside that police vehicle, were you taken somewhere?
Yes, sir.
Do you remember which officer was driving the vehicle?
Yes, sir.
Who? Which one?
I was Vitriano.
And who was Vitriano's partner officer at that time?
Officer Furman,
All right. And where was Officer Furman seated in the vehicle, if you recall?
on the passenger side of the vehicle,
And where were you seated?
in the rear of the vehicle.
Were you handcuffed at that point?
Yes, sir.
And did Officer Furman say something to you as he was seated in the right front passenger seat and you were in the rear portion of that police vehicle?
Yes, sir, he did.
Can you tell the ladies and gentlemen of the jury what Officer Furman said to you on this date in January of 1987?
Yes, sir. At the time, Officer Furman turned around, looked at me, and told me, "I told you we'd get you, nigger."
Did you hear what you heard him clearly?
Very clearly, sir.
And when he said this to you, can you describe for us the tone of voice that he used?
Anger, hatred, just something from deep inside, if you would, just very ugly.
And when he made this statement to you, can you describe for the jury how you felt? Oh.
Belittled, scared, very, very angry. I could use many more adjectives, but those
Does that encapsulate how you felt?
lightly, yes. Very lightly.
Well, thank you very much for coming today. Thank further, Your Honor.
People?
Mr. Hodge, thank you for coming, sir. Sir, you live on Morgan Avenue, was it?
Yes, sir.
You were arrested by Petrano and Furman on January 13, 1987, is that right?
I'm unable to call the exact date, sir.
By the way, were you only arrested once by Petrano and Furman and placed in a police vehicle?
Object to any Beyond scope,
Sustain.
Trying to establish the date, Your Honor.
The date of January 87 is close enough.
Then perhaps I should approach then.
All right, let me see over here at sidebar with the court. Thank you, counsel. Proceed.
Mr. Hodge, did you complain to the LAPD about the manner in which you were arrested by these two officers?
On which occasion, sir?
On the occasion you just described for Mr. Cochran.
Yes, sir.
You filed a formal complaint?
Yes, sir.
When you were arrested, were you holding a drill or something in your hand?
Sustain.
Let me show you a copy of an IED complaint. By the way, Did you have any portion at all of the IED complaint you filed?
At this time,
Excuse me, counsel, I think your question assumes IAD and that the jury
Okay.
knows what we're talking about here.
Certainly. Okay. You complained to Internal Affairs Division at the LAPD. Is that right?
I believe it was internal affairs, yes, sir.
Okay. And you were interviewed by them?
Yes, sir.
Okay. And were you interviewed by a supervising officer at West LA Station as well?
I believe it was a supervising officer.
Okay. And your name is Robert T. Hodge. Is that correct?
No, sir.
Okay. What's your name?
Roderic T. Hodge.
And what's your birthday?
August 22nd, 1964.
I just showed. I'll give Mr. Cochran a copy.
All right.
Is that the, if you just take a look at that, please, sir.
Right.
Does that refresh your recollection that the date of arrest was January 13, 1987?
Not really, sir, but take it.
Okay. Does that appear to be the complaint that you filed with LAPD?
Yes, sir, it does. It
Okay.
appears to be.
Okay. And on the last page of that document, does it indicate that you had a second interview with someone from Internal Affairs on January 23, 1987, an interview with a Sergeant Lamprey?
Yes, sir, it does indicate that.
Okay. And did you have such an interview?
Yes, sir, I believe so.
Okay. Nowhere in this Internal Affairs complaint is it mentioned that you complained of Furman's use of any epithets. Is that correct?
I haven't read over the entire of the interview, sir.
Okay. Your Honor, may this document be marked People 604?
People's next in order, 604.
Would you like to take a moment and see?
How many pages is this document, Mr. Darden?
It's 17 pages, Your Honor. Other than in response to this question, I have no additional questions.
All right, since it appears to be typewritten,
Yes, sir.
single page. All right, then what I'm going to suggest we do is allow Mr. Hodge the time to review the document, and we'll conclude the examination after the lunch hour. All right, ladies and gentlemen, we're going to take our recess for the morning session. Please remember all my admonitions to you. Don't discuss the case amongst yourselves. Don't form any opinions about the case. Don't conduct any deliberations till the matter has been submitted to you. Do not allow anybody to communicate with you with regard to the case. As far as the jury is concerned, we'll stand in recess until 1:30. All right, Mr. Hodge, you can step down. All right, thank you.